So hi, everyone, and welcome to our Privacy and Data Security webcast presented by Law Squared. I'm Katie, a privacy and commercial lawyer at Law Squared, and I'm your host today. I'm excited to be joined by Chief Realist at Phronesis Security, Elliot Dellys, and my colleague, Jon Crass, a privacy and commercial lawyer at Law Squared as well. Welcome both, and thanks for being with us today.
Thanks for having me, Katie.
Thanks for having us, Katie.
So today we're focused on the challenges for businesses, in particular their in-house legal teams, navigating the requirements of the Privacy Act, specifically in terms of complying with the law in relation to protecting personal information. Anyone following the headlines and news over the past year will know that we've seen a huge rise in cyber attacks occurring, creating a lot of damage not just for impacted customers whose data has been breached, but also for the reputation of the businesses who are responsible for keeping that data safe. Just to put this in context, two of the well-known 2022 breaches, Optus and Medibank, impacted between 2.2 million and 9.7 million individuals respectively, and the more recent attack on Latitude Finance left nearly 8 million individuals impacted and the business scrambling to try and recover. So whether these breaches are caused by malicious attack, human error, etc., they're the number one issue that's keeping management and C-suite awake at the moment. At Law Squared, we specialize in working with in-house legal teams to improve their privacy and data practices and to support them in the occurrence of a data breach, as well as that front-end compliance as well. The Privacy Act does provide a framework for the legal obligations of businesses when it comes to actual on-ground understanding of how to go about the data handling practices and the security of data. These provisions are often poorly understood and applied, and they're only understood by a few people in the business and more broadly. These are also often not the people dealing with the data in the day-to-day. So, Elliot, you're the Chief Realist at Phronesis. Can you tell us a little bit about what that title means and share your perspective from a cybersecurity side on how things are evolving in this space and in respect to personal information?
Yeah, absolutely. We often talk about security as being a balance between convenience and security. You need your data to be accessible to the people that make use of it, but you have to be able to control it. And so my business partner and I are the Chief Realist and the Chief Optimist, respectively, because we want to try and achieve an ideal end state, but obviously that needs to be tempered by the reality of the resources that you have and the budget that you have available. One of the big trends that we've been seeing off the back of the breaches of 2022 is a lot of organisations scrambling to understand what data do they actually have out there. The last 15 years or so has often been described as the era of data being the new oil. That is, everyone's trying to collect and use as much data as they possibly can. We live in an era that is driven by data. And I often say to people, if you're using a platform and you're not paying with money, you're probably paying with your data because it's incredibly valuable. The transition that we're seeing at the moment is thinking more about data like being uranium. It's still incredibly powerful, but it's very dangerous if left lying around. And a lot of organisations now are trying to understand what data do we have and how long have we been holding on to it, and have we exceeded our retention periods, and what can we do to start to get rid of that data that we don't use anymore, or how can we anonymise and reduce the risk of the data that we do still hold on to.
Awesome. Thanks, Elliot. So it sounds like we have a fast evolving landscape and we have the law, we have various cybersecurity requirements as well, but these aren't always well understood. This can add up to risk for businesses, sometimes lower risk, sometimes significant risk, depending on the business. So over to you, Jon. Can you give us a brief recap on the Privacy Act's requirements and its relationship to what we're talking about today in terms of data handling and protecting your business from cyber attacks?
Yeah, sure. Thanks, Katie. So the Privacy Act has quite a lot in it, as many of you would well know. The core parts that most people talk about is what's called the Australian Privacy Principles, and they're in the back of the Privacy Act. When we're talking about security, we're talking about what's called APP 11, or Australian Privacy Principle 11, and that is quite vague when it comes to actually implementing those security measures. into a business. So the legal wording or the legal requirement for it is to have steps or to take steps that are reasonable in the circumstances. Now, a common question we get from a lot of businesses and a lot of clients is, what does that mean? There isn't a great deal of guidance out there about what that actually means. Regulators who are tasked with providing a lot of this guidance oftentimes don't really know themselves what really that means, because it's so situational. It's so based on what the business is doing and what data you actually hold. So that's one of the core challenges with sort of implementing APP 11 and the Privacy Act more broadly. But we are starting to see that those requirements are looking to be fleshed out in the upcoming reforms that are proposed for the Privacy Act.
Thanks, Jon. So quick jump here. And for you both, one of the key points in this particular webinar is to clarify the role between what your cybersecurity provider can help with and also what legal can help with. So let's say somebody's business has been subject to a data breach. Who should they call and when do they call them? And also, how can your cybersecurity provider and your lawyer work together in managing that response? We'll start with you, Elliot.
Yeah, if a breach has occurred, you definitely want to be speaking to a cybersecurity professional and a lawyer in tandem. So a cybersecurity professional can help you immediately triage the incident. So what we usually talk about is the first two stages are containment and eradication. Containment is really, really important because you need to understand the scale of the breach. You need to understand what sort of data has been affected. And if there are mechanisms in place to be able to try and limit the harm that might be caused from a data breach, they are often going to be technical measures. So, for example, if an encrypted database has been impacted, then being able to rotate encryption keys can render that data useless to a potential attacker. So that can be quite valuable, and you need to act very quickly to be able to do some of these containment measures. By the same token, it's incredibly important to engage a legal professional to understand what are your reporting obligations going to be off the back of this. If you're subject to the notifiable data breach scheme, for example, or if you're a critical infrastructure provider and you're subject to the SOCI Act, then you are going to have to make sure that those legal obligations are well understood by the incident response team, so you're collecting the right information and reporting accordingly. So absolutely, when we work with organisations to help them prepare for an incident, one of the key things that we do is say, do you understand who's going to have to be on that incident response team? And if a data breach is suspected, you absolutely want your legal professionals there to help.
Awesome. Thanks, Elliot. And I know myself, when a client's contacted me, for example, and they've said, oh, I've had a data breach, I've gone, okay, cool, we need legal and we need cyber both at the same time. Jon, did you have anything to add?
Yeah, I think so. I think a couple of things to add into that. The first thing I'd add from the legal perspective is responding to a data breach really starts well before the data breach actually happens. It really is a lot of the hard work can be done in preparation. So having things like your data breach response plan, having your incident response plan kind of drafted, ready to go, and everybody actually understanding how to use that and how to implement that. The last thing you want to see is a data breach happen and everybody's turning to everybody else saying who does what and what do we have to do. That's normally going to waste a lot of time doing that, and that will hamper any sort of recovery efforts that you might have in order to mitigate that. The other side of once a breach does happen, and unfortunately it's not a matter of if, it's normally a matter of when, but your notification requirements and notification obligations, yes, they are to regulators, and yes, they are to law enforcement and those type of things as well. But it's also to your customers. Understanding that fundamentally your customers are going to be impacted by this as well, not just you as a business. We often say is very, very often a opportunity to build that trust with your customers, because unfortunately mistakes happen and then breaches happen. But you can see it as an opportunity to build that trust with your customers by being upfront and transparent about how you're responding to that breach, and then assisting them in sort of any way that you reasonably can in terms of mitigating the impacts that they could have on that. And that's really one of the areas that we do see in Australia isn't quite as well done as it is overseas. Oftentimes you hear of data breaches that have occurred years ago and they're only just coming out and people are finding out in the media, when they really should be contacted by the company, even if the company doesn't have a legal obligation to notify on it. It's just good business practice.
Awesome. Thanks, Jon. So As a next step, then, Jon, it'd be great if you could go through what the requirements are in terms of adequately protecting personal information in the eye of the Privacy Act and the kind of minimum that businesses need to do to remain compliant from the legal side. And then, Elliot, I'll throw to you for that cyber side, or what you consider at least in that cyber side.
Yeah, definitely. It's unfortunately, from a legal perspective, it's the classic lawyer answer of it depends. It really comes down to what your business does, how sophisticated your business is from an IT perspective and from a cyber perspective, and really what type of information are you actually collecting. So in terms of the practical measures, in terms of implementing appropriate security measures, it's understanding what you have, understanding what systems you have, understanding your supply chain. So, for example, if you're an online retailer, who's your website built by? Is it by Squarespace or someone like that? Is it built through Canva? Are you using something like Shopify, for example? And really understanding exactly what these platforms are doing with that information and where that's going, because if you think of where the information is going a bit like sort of tentacles going across the internet, they can go far and wide, unfortunately. And when you have a data breach, you really have to understand exactly where that data is going. So understanding where the data is going is vitally important. And then when we're talking about trying to drill down into the legal wording of reasonable measures, it does depend on what type of business it is. I mean, we've seen clients that relatively, I'd say maybe unsophisticated in terms of the IT side of things. It can be a small business or something like that, which doesn't need a lot of protection. But it's things like, do you have multi-factor authentication? Are you changing your passwords regularly, or not having basically password 123 as your password to log in? It's these sort of really basic measures. And I understand people have been told this over and over again for the last probably 10, 15 years. But it really is kind of the first line of defense. As for more sophisticated measures, I'm not even going to try and speculate on that because that's not my area of expertise. That's very much Elliot's area of expertise. So I'll throw over to him for those sort of things. But lastly, I would say on the legal side of it is, and this is more from a practical side of things than the legal thing, it's, can you reasonably defend what you've done to a regulator? So if a regulator comes asking, or is an investigation or some questions, can you adequately formulate what you have done and why that was reasonable in the circumstances? And it's a piece that very few people tend to think about, because ultimately, let's be honest, regulators are busy people. They've got a lot to investigate. And if we can give them the comfort that we have complied with the law and taken those reasonable measures, then they're much less likely to really open a can of worms when there doesn't have to be.
And Elliot, so speaking to that reasonable steps piece, I'd be interested in hearing about what are some of the first questions that you ask a client, for example, that comes to you and says, okay, my lawyer said I need to take reasonable steps. They've also said it depends when, they ask more about what that means. Yeah, I'm keen to know what you ask about, and then also what do some of those reasonable steps look like for varying sizes of businesses?
Yeah, for sure. I think Jon's hit the nail on the head. I think most lawyers don't have that depth of understanding of the technical controls, but his point is spot on. Most organisations fall over from not doing the basics well. It's usually not about the highly complex technical controls. It's about not consistently applying the controls that do exist in the organisation. And if we do look at the adverse findings that the Information Commissioner and regulators have, it's usually about that lack of consistency and that lack of due diligence and making sure that controls have been properly applied. If we look at some of the breaches over the last couple of years, we see things like sensitive data being put on internet-facing repositories without any access controls being put in place, which is obviously a product of organisations often thinking they're setting something up just for an afternoon, just a temporary measure. We're just going to test something, forgetting about it. It remains exposed to the internet, and 6 months later it gets compromised. So one of the things I always talk to organisations about doing if they are concerned about limiting the likelihood or the severity of a data breach is do the basics well. So one of the concepts we often talk about is the principle of least privilege. That is, if you're going to provide access to sensitive personal information, do so according to the minimum amount of access required for a person to be able to do the duties. And then also have the mechanisms in place to be able to recognize when someone leaves the organization or when they change roles to deprovision that access as well. Access accumulation is one of the things that we see very, very frequently, where someone has been in the organization for, say, 10 years, they've changed roles 3 or 4 times, and they've accumulated these privileges over time. That means that that account is now incredibly valuable for an attacker to compromise because they essentially get the keys to the kingdom. So a lot of the time, organizations don't get compromised because they're being careless or flippant. It's just about not doing that regular housekeeping to make sure that if you do have sensitive information that's in a test environment, you get rid of it when it's no longer required. If you have users that are changing roles or perhaps they need elevated privileges to do something, get rid of those privileges and get rid of those accesses once they're no longer required. But definitely often the big challenge is just understanding what's out there. And organizations do need to take the time to do data discovery exercises, speak to their legal team to understand what are the data's retention requirements, and then get rid of it when it's no longer required. Often you'll still need to hold on to data for archival purposes, but once it's safely archived away, you've backed it up, you no longer need immediate access to it, then just get rid of it.
Yeah, that absolutely makes sense, Elliot. And I think building on that, at Law Squared, we do a lot of work with in-house legal teams. So, Jon, I'd be interested in your comments on what you see the role of the in-house legal team as being in relation to both taking that reasonable steps to protect data, but also in terms of data retention as well.
Yeah, definitely. I mean, in-house legal teams, and particularly where there's a sole in-house counsel, they tend to get lumped with everything that nobody else wants to touch. Unfortunately, it's kind of the joy of the job, really. But by necessity, you kind of become a jack of all trades in that. And I think the key part that in-house legal teams can do on this is not only be sort of a source of comfort and a source of truth for the business, but also for the exec and for the board as well. So understanding fundamentally what information is flowing through the business. That's job one. You don't have to know it in a super amount of detail, but you need to have a good understanding that you're comfortable that what is being collected and what is being used and disclosed and stored is being done so in appropriate ways. I would also, to add to that, I would also say know where to go to get the technical information. In a previous life, I worked in-house in a couple of different companies, and the biggest benefit that I found was knowing who to talk to in the IT team, knowing who to talk to in the marketing team, knowing who to talk to in the sales team. If I had a particular question, who were my other sources of truth within the business? So understanding who those people are and cultivating those relationships. So when something does go awry or something complex does come across your desk, you think, oh, I know XYZ in the IT team, they can give me a heads up on how to handle this, or they can give us a heads up on what measures are in place. That's definitely one thing that you can definitely do today. The other part of it, I would say, and this is, I know a lot of people get told to do this a lot, but it's also staying up to date with what's actually happening. Now, this doesn't mean you need to be a subject matter expert in terms of cybersecurity or even privacy law for that matter. But it's good to understand what's actually happening in the landscape. So, for example, understanding that ransomware attacks, they're not going away anytime soon. There's a whole bunch of different actors, understanding sort of where those ransomware attacks are really coming from and who might possibly be a target. For example, we've seen the last sort of year or so, government contractors really being a prime target for ransomware attacks because governments tend to have very strong security, but their outsourced services may not. And that's why we're seeing a lot of these service providers getting attacked. So understanding whether you're a target or not is also a good way to do it. And then I think the last sort of real piece of value you can add to your business is understanding what the responsibilities are for each level of the business. So if a breach happens, who's responsible for briefing the board? What are the board's responsibilities and when that happens? Who's responsible for fixing it, for doing the triage, for doing the response, for doing the containment? So you almost want to be the person that everybody turns to and says, how do we fix this? Yeah, no problem. I've got a plan for that. You do this, you do this. That's the real value. I think you can do that. And then just, as in-house counsels are always doing, cultivating those relationships with external advisors so they can get the help they need as soon as humanly possible.
Awesome. Thanks, Jon. And so, Elliot, in terms of those relationships and working together. So in-house legal wears many hats. They have a lot of different stakeholders that they manage and connections that they have. In terms of the cybersecurity side, who are you often dealing with in a business, for example? And then how could working with in-house legal make your role easier, for example?
Working with in-house legal always makes our lives much, much easier. The first thing that we have to understand is what is of value to the business and what are our legal and regulatory obligations. That then sets the foundation on which everything else is built. Some of the key stakeholders we'll always talk to, for example, is the finance team. Business email compromise is hands down the most lucrative form of cyber attack, 64 times worse than ransomware, in fact, according to the latest Verizon data breach report. So incredibly lucrative. For those that don't know, a business email compromise attack, you've probably seen one of these before, is where you masquerade as someone internal to the business in order to try and say something like, can you please go and pay this invoice, it's overdue. Invoice gets paid 6 months later, an angry vendor says, why was this invoice never paid? And you find out that in fact that email was fraudulent. Very, very common, very, very effective. Often a conversation with the finance team is a good way to get ahead of that. The HR team, incredibly useful as well. As I mentioned earlier, accumulation of privileges is a really serious concern. This isn't something that the IT team can handle on their own. They don't necessarily know how people are moving around the organisation. So being keyed in with the HR team to understand who needs access to what is incredibly important. But the other thing as well, and going to Jon's point about knowing the right places to get information, is having good, reliable sources of cybersecurity information. For example, multi-factor authentication is one of the best controls you can implement to reduce the likelihood of someone getting access to your environment. One of the most effective attacks for countering multi-factor authentication is simply to try and log in again and again and again. We've seen Russian threat actors doing this. The user just gets frustrated with seeing these pop-ups again and again, goes, yes, just go away, stop annoying me. Simply being aware that that is an attack method is an effective way of being able to combat it. If users are aware, if they see a notification popping up again and again and again, hey, that's a red flag, better get in touch with the cybersecurity team or the help desk, whoever it might be, is a really, really good way to just make sure that that baseline level of awareness is elevated. So we generally try to understand, how is the organisation using its data? Who are the people that are most likely to be targeted? Every organisation can be a target, and the reason for that is simply attackers are opportunistic. They might not even know the name of the organisation they're attacking. They just know that there's a vulnerability in an endpoint somewhere, or they might have access to someone's password. That's all they need to try and target you and try to get into the organisation. So usually what we're trying to do is make sure that there's that base level of awareness, and also, again, to Jon's point, if there's relevant threat intelligence. So, for example, we saw about a year and a half ago, a number of Russian ransomware crews started actively targeting Western critical infrastructure providers for geopolitical reasons. So being aware, okay, we might have a heightened threat profile as a result of what's going on in the wider world. Just that little bit of advanced warning can make all the difference if you are, in fact, targeted for an attack.
Awesome. Thanks, Elliot. And so taking that step back to those minimum requirements again, in terms of a legal perspective, Jon, just going through the absolute minimum requirements, what would those be? And then also, do we need to be doing more in addition to that?
Yeah, so the minimum requirements that I would see, or most currently see that clients should be implementing, is multi-factor authentication as an absolute baseline, having a good password management system. So new members and existing members are constantly updating those passwords. I know it can be annoying, particularly when you get that message pop up before you log in saying it's time to change your password again. But it really does prevent a lot of the incidents that do happen. I would also say having a good access management system or access management process. So there's no reason why somebody who left the business 6 months ago should still have access to your systems. And this is an issue we really see with people like contractors coming into the business. They're given access, they leave 3 months later, and they still have access 12 months later. Like that's just, you don't need that at all. And it's honestly just creating a problem you don't need. So having good access management as well is a real point there. And then I think, Elliot, you were mentioning earlier on about retention, really understanding what information you have and how long you're retaining it for can actually cure a lot of potential issues before they even arise. There is normally a document that is associated with this. So, for instance, under the GDPR in the EU and the UK, it's a data retention policy. We don't strictly have a legal requirement for this under the Australian Privacy Act. However, it is considered good business practice to have that. And it should be something as part of your privacy policy where you're explaining to people, this is what information we're collecting and this is how long we're probably going to keep it for, unless there's some other legal requirement. And then taking the next step of enforcing that. So it's all well and good to have a policy, but this is the usual case that happens with policies. They sit on the shelf and they gather a bit of dust, and then all of a sudden someone dusts it off and say, well, why haven't we implemented this in 6 years? It's quite a common occurrence that we come across, unfortunately, but making sure that implementation is happening of those policies is also quite vital.
Thanks, Jon. And Elliot, do you have any additional tips to share on top of that?
Absolutely. So we often talk about cybersecurity in terms of people, process, and technology. A lot of organizations focus on the technology, ignoring the fact that the people and the process are actually critical to making it all work. So that's the first thing I'd say is think about a baseline, not just in terms of the technology, but also are your people empowered to know what they should and they shouldn't be doing with data? Are they trained and educated on common threat and attack types? And also, are there documented procedures in place for, say, transferring data to authorized third parties, where you can and you can't store data on your internal systems? It's all well and good to have policies that say all of our sensitive personal data is stored in this one particular location, but if there aren't processes in place to enforce that and people aren't aware of it, then that policy is essentially just a piece of paper. On the technology side, what I would say is a handful of controls implemented effectively is generally far more effective than trying to do everything under the sun. So the Australian Cybersecurity Centre, for example, publishes what it calls its Essential 8. It's called the Essential 8 because, according to their data, 85% of targeted intrusions are mitigated by effectively implementing these 8 controls. We've talked a lot about access control. The only other point I'd make there, Jon, I love your analogy about the octopus's tentacles through the internet. The longest of these tentacles is SaaS applications, so things like Salesforce and CRMs and things like that. So often, we're so focused on the technology that we manage, forgetting that all of this data is stored in these SaaS applications. And one of the things as well is when people leave the organization, you might deactivate their access on Active Directory for all of your network infrastructure. But what about all of these SaaS applications? Sometimes your most sensitive data is stored there and you're not even aware that people still have access to it. In terms of the Essential 8, just very quickly, patching operating systems, patching applications, absolutely critical. Restricting local administrator privileges again, so malware can't even get a hold if someone accidentally does the wrong thing, is super, super important. But as well, having MFA in place, having backups in place is a really good way to have some assurance that if something does go wrong, you can restore quickly and effectively, and you can contain it so it doesn't get out of hand.
Awesome. Thanks, Elliot. So, Elliot and Jon, it's been awesome to have you on the webcast today. If there's one takeaway piece of advice that you could share with listeners, what would that be? Starting with you, Jon.
The number one thing, and it's been the message from the Privacy Commission in the last couple of months, is know what you have. Map your data, understand the problem before you go it. You should never, when you're talking about personal information and the data that you're collecting as a business, the answer should never be, well, I don't know, or there should never be any unknown unknowns. You should always know exactly what data you have. So I would say the number one tip that I can give people in terms of securing your information is know what you have. You can't fix the problem if you don't know it.
Awesome. Thanks, Jon. Elliot?
For me, I think it would be don't assume that it wouldn't happen to you. The sad reality is, I've worked with charities that have been targeted by these sorts of, awful attacks. It doesn't matter how noble your mission is, how good your people are. At some point, things will go wrong. And the more that you do in advance to prepare for it, the better off you'll be. Unfortunately, a lot of major breaches are just the result of human error. People trying to do the right thing, wanting to be helpful, but accidentally violating the security controls of the organization. So the more that you can do in preparation, the more you can anticipate how something might go wrong, where data might be compromised, then the less thinking you have to do if and when it actually occurs.
Thanks, Elliot. So thanks, Elliot and Jon, for today. And to our listeners, I hope that you found our session useful. If you have an immediate privacy or data or cybersecurity concern, or you're unsure where to start, please reach out and connect with myself, Jon, or Elliot, or of course via the Law Squared website. And please don't forget, we welcome you to submit any questions for Jon, Elliot, or myself in the chat function here. We'll collate all of these and come back to you with answers in our FAQs. Thanks for listening.